The same week the Trump administration's ATF was dismantling decades of federal firearms regulation, the governor of Virginia was signing the most aggressive set of gun restrictions in the state's recent history. April 2026 produced a contrast rarely seen in American gun law. The federal government moving aggressively toward deregulation and multiple states, led by Virginia, moving aggressively in the opposite direction. If you live in Virginia, own an unfinished firearm frame or receiver, plan to buy a semi-automatic rifle, or own magazines over 15 rounds, what Governor Abigail Spanberger signed into law in early April affects you directly. And there is a date you need to have circled right now, July 1st, 2026. On that date, Virginia's assault weapons ban takes effect, and the grandfathering window that currently allows you to purchase the firearms and magazines that will be banned closes permanently. Subscribe now because the July 1st deadline is a hard cutoff. After it, certain firearms and magazines will be illegal to sell or purchase in Virginia, and the gap between what you can buy today and what you can buy on July 2nd is significant enough that Virginia gun owners need to make specific decisions before that date arrives. Governor Spanberger, describing these bills as common sense steps that will help keep Virginia families, communities, and law enforcement officers safe, signed two categories of legislation in early April. First, the ghost gun prohibition under Chapter 532, taking immediate effect and creating criminal liability for possession of unserialized commercial firearms, unfinished frames and receivers, and other components known as ghost guns. Second, the assault weapons and magazine restriction under Assembly Bill 217 and Senate Bill 749, banning future sales of certain semi-automatic firearms and magazines with capacity over 15 rounds, with a grandfathering clause exempting firearms purchased before July 1st, 2026. Parallel restrictions were simultaneously implemented in Minnesota, Colorado, and Rhode Island, demonstrating Virginia's legislation as part of a coordinated multi-state effort. Let me break down each component, the legal challenges being prepared, the July 1st deadline and what it means for your purchasing decisions, and the broader state versus federal conflict this April moment represents. Number 1. The ghost gun ban under Chapter 532, effective immediately. What Chapter 532 prohibits. Virginia's ghost gun ban makes it a criminal offense to sell, transfer, or possess an unserialized commercial firearm, manufactured by a commercial entity without a legally required serial number, an unfinished frame or receiver, whether in completed or incomplete form, lacking proper serialization, and parts or kits intended to be assembled into an operational firearm lacking serialization. The ban targets the class of firearms called ghost guns, weapons assembled from commercially available components or manufactured through 3D printing that are not serialized and cannot be traced by law enforcement. The VCDL's constitutional challenge. The Virginia Citizens Defense League immediately announced a constitutional challenge grounded in Bruin's historical tradition analysis. Home gunsmithing, manufacture of firearms for personal use without commercial serialization, has been legal in the United States since before the Republic's founding. Colonial-era Americans routinely manufactured and assembled firearms without any government serialization requirement. No founding-era analog for mandatory serial numbers exists in the historical record. Under Bruin, a regulation without historical analog fails constitutional scrutiny. The VCDL has signaled it will file or support litigation challenging Chapter 532. What this means for you right now: if you currently possess an unfinished frame or receiver, or a 3D printed firearm without serialization, Virginia is now claiming criminal jurisdiction over that possession. Unlike the assault weapons law, Chapter 532 does not contain a grandfather clause for current possession of unserialized firearms. If you are a Virginia resident with unserialized firearms or unfinished frames, consult an attorney about serialization options through an FFL before enforcement action occurs. Number 2. The assault weapons ban under HB 217 and SB 749, and why July 1st is your deadline. What the ban prohibits after July 1st. HB 217 and SB 749 ban the future sale, offer for sale, or transfer of certain semi-automatic firearms classified as assault weapons, semi-automatic center-fire rifles with any of the following features: pistol grip, thumbhole stock, folding or telescoping stock, flash suppressor, forward pistol grip, semi-automatic pistols with similar features plus detachable magazines. Magazines with capacity over 15 rounds are also banned from future sale or transfer. The grandfathering clause and why it matters. Firearms and magazines purchased before July 1st, 2026 are explicitly exempt. If you purchase a covered firearm or over 15-round magazine before that date, you can keep it permanently. You cannot be forced to surrender or destroy it. You can possess it, use it, and pass it to heirs. What you cannot do after July 1st is buy a new one, have one transferred to you, or receive one as a gift in Virginia. The grandfathering clause was included, according to legislative history, to reduce immediate constitutional challenge risk. Banning existing possession would likely fail under Heller, while banning future sales creates a harder fight for challengers. Your purchasing window is closing. If you want an AR-15, AK-47, or any semi-automatic rifle with prohibited features and do not currently own one, the window to purchase it and be protected by the grandfathering clause is weeks. July 1st, 2026 is not a distant date. The same applies to magazines. If you want to own standard 30-round AR-15 magazines or 17-round Glock magazines as a Virginia resident, purchase them before July 1st. After that date, your Virginia dealer cannot legally sell them to you. Document everything. If you purchase a covered firearm or magazine under the grandfathering window, preserve your receipt with the date clearly shown. That documentation is your evidence that your firearm was acquired before the effective date. Keep it with the firearm. Number 3. The NRA's position and the constitutional challenge landscape. The NRA's criticism. The NRA Institute for Legislative Action issued sharp criticism framing Virginia's legislative package not as a response to Virginia's specific crime dynamics, but as the implementation of a national agenda supported by billionaire donors, a reference to organizations funding gun restriction campaigns across multiple states simultaneously. The NRA's framing points to the coordinated nature of the multi-state movement. Virginia's laws did not emerge from a unique Virginia problem. They emerge from a legislative template being deployed simultaneously in multiple blue states, reflecting a nationally organized strategy for advancing gun restrictions through state legislatures that a consolidated Supreme Court challenge cannot easily address all at once. Why the grandfathering clause is a strategic legal choice. The grandfathering clause in HB 217 and SB 749 is not primarily a concession to gun owners. It is a litigation strategy. By limiting the ban to future sales, the legislation avoids the direct confrontation with Heller's holding that the government cannot prohibit possession of firearms in common use. An existing possession ban would require Virginia to argue AR-15s are not in common use, an argument the Supreme Court has essentially already rejected. A future sales ban pushes the constitutional question onto whether a state can prohibit acquisition of commonly owned firearms, even if it cannot prohibit possession of those already owned. The drafters knew this is a harder fight for challengers. The VCDL's Ghost Gun Challenge. Virginia will need to identify a historically grounded justification, perhaps analogs to laws regulating the sale of weapons by itinerant traders or requiring proof of ownership in certain contexts, to defend Chapter 532. Whether those analogs are close enough under Bruin is the question that will be litigated over the next 12 to 18 months. Number 4. The parallel state restrictions and what Virginia gun owners must do before July 1st. Minnesota, Colorado, Rhode Island. Minnesota implemented ammunition age limits extending beyond federal requirements. Purchasers of certain calibers must be 21 rather than the federally permitted 18. Colorado added a licensing layer requiring buyers of certain semi-automatic firearms to complete an application, pass an enhanced background check, and receive state authorization before purchase. Directly analogous to New York's licensing requirement upheld in Gazzola v. James and building on that doctrinal foundation. Rhode Island implemented similar parallel restrictions. The convergence of Virginia, Minnesota, Colorado, and Rhode Island in the same month is not coincidental. It reflects a coordinated strategy of creating legal facts on the ground that require individual constitutional challenges in each state, challenges that take years and resources to prosecute. Even if every law is eventually struck down, the period in effect creates behavioral change and market change. The purchasing decision before July 1st. If you want any firearm covered by HB 217 and SB 749, semi-automatic centerfire rifle with prohibited features, covered pistol, or magazine over 15 rounds, and do not currently own one, decide now. The closer you get to July 1st, the more demand concentrates at Virginia dealers, Prices may rise, models may sell out, and dealers may be overwhelmed. Act with time to spare. Documentation of existing ownership. For firearms you already own that may be covered by HB 217, document your existing ownership with whatever evidence you have. Purchase receipts, transfer records, credit card statements from the purchase date, or signed statements from witnesses. Ghost gun compliance now. If you have unfinished frames, receivers, or unserialized commercial firearms, consult a Virginia attorney about Chapter 532 immediately. Understand whether FFL serialization is an available option. Do not rely on an anticipated injunction for your July 1st purchasing decisions. Injunctions are not guaranteed, and the window closes whether litigation succeeds or not. Bottom line, April 2026. Virginia Governor Abigail Spanberger signed Chapter 532, immediate ghost gun ban covering unserialized commercial firearms, unfinished frames, and receivers. Also signed HB 217 and SB 749, assault weapons ban and magazine restriction over 15 rounds effective July 1st, 2026, with a grandfathering clause protecting firearms purchased before that date. VCDL challenging. Chapter 532. No historical analog for serialization requirements under Bruin. Constitutional challenge being prepared. NRA characterizing Virginia's laws as part of coordinated national agenda, not response to Virginia-specific crime. Minnesota, Colorado, Rhode Island, parallel restrictions including ammunition age limits, enhanced licensing, and similar frameworks, demonstrating coordinated multi-state strategy. July 1st, 2026. Hard deadline for Virginia purchases of covered semi-automatic firearms and magazines over 15 rounds. Document all purchases. Ghost gun compliance requires immediate attorney consultation. Subscribe because the constitutional challenges to Virginia's laws will be filed in the coming weeks, and every ruling on those challenges directly affects whether these restrictions remain in effect or are enjoined pending final resolution.